Hello, this is Steve Carlson, the Independence Party's nominee for Congress in 2012. And what I am doing today is revealing to the voters of Minnesota and the 4th Congressional District what is going on in the public, political, and constitutional litigation surrounding the CD4 elections, where both the Minnesota Supreme Court and the Federal District Court of Minnesota are considering litigation that is lodged against Mark Ritchie, the Secretary of State, and also the DFL party, and Betty McCollum, who is the incumbent and who has been sworn in as the representative from the 4th Congressional District from Minnesota to the U.S. House of Representatives. And so I'm reading from a draft of a response to Secretary Ritchie, this one from the federal lawsuit. A hearing on this matter is scheduled in federal court for March 15th, 2013. This is plaintiff Stephen W. Carlson's response to defendant Mark Ritchie's motion to dismiss. Defendant's motion is purportedly based on the grounds that this court lacks subject matter jurisdiction over the instant action. So plaintiff failed to state a claim for which relief can be granted. In support of their motion, defendant Secretary of State Mark Ritchie and OSS legal counsel Burt Black assert that the suit should be dismissed because, they say, it is based on 1. Non-existent constitutional rights, 1st and 14th Amendment U.S. Constitution, 2. A total disregard of the 11th Amendment to the United States Constitution and Minnesota case law interpreting the state statutes at issue, and 3. Speculative, quote, indeed false assumptions regarding central facts. Plaintiff asks that the court deny defendant's motion and allow the case to proceed to the pretrial conference the parties have been instructed to seek. There has been no opportunity for discovery or to refute the wrongful factual claims submitted by defendants as the basis for the dismissal they seek, and that opportunity should be granted before they are entitled to any dismissal on the grounds, including factual grounds, they assert. The violations of these constitutional rights runs counter to the Buckley Court's command that the court guard elections to, quote, assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people, unquote. And a footnote. Buckley states, in the past 2 decades, the court, this is the Supreme Court, has frequently spoken of the broad coverage of the First Amendment, especially in the area of political dialogue, quote, to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people, citing Roth versus United States 354 U.S. 476 from 1957. Moreover, defendants in the state of Minnesota advocate for the violation of the 15th and 19th Amendments U.S. Constitution by positively stipulating fixed percentage proportions of those who may vote based on race, color, and previous condition of servitude, and on sex. The suit is not barred by the 11th Amendment, it is not moot, and is in conformity with Minnesota election laws and Constitution, which are in turn regulated by and must conform to the federal Constitution and laws. And defendants Ritchie, as Minnesota's chief elections officer, and Black are the officials responsible for the constitutional implementation of those state laws, which as applied in this case are in violation of the U.S. and in fact Minnesota constitutions. And plaintiff will show and support the plausible facts alleged in the complaint that they are not speculation nor false and have not been shown to be so in defendant's motion to dismiss. Facts. As defendants set out in their memorandum supporting their motion, the court must determine whether the complaint, together with matters of public record, orders, materials embraced by the complaint, and exhibits attached to the complaint, contain, quote, enough facts to state a claim for relief that is plausible on its face, citing Twombly. That's a U.S. Supreme Court case. These parts of the record must contain facts with enough specificity, quote, to raise a right to relief above the speculative level, that's also Twombly, and not mere conclusory statements. The court must assume all facts in the complaint to be true and construe all reasonable inferences from those facts in the light most favorable to the complainant. That's me. Neither wholly conclusory allegations or legal conclusions drawn by plaintiff need be accepted as true, and plaintiff, in bringing this case, does not ask the court to accept either wholly conclusory allegations nor legal conclusions drawn by plaintiff. But they must be construed in the most favorable light in deciding this motion. It follows that the court should consider the record of A12-2286, an ongoing election petition at the Minnesota Supreme Court, which includes a proceeding to void the CD4 election and a footnote to clarify. Neither this court nor any Minnesota court or any court may void the CD4 election or any election for the U.S. House of Representatives, since that power, or any power concerning the membership of that body, lies solely with the House itself, under the U.S. Constitution. And Minnesota provides a method in Minnesota Statutes 209.21, congressional elections, to collect evidence relating to the selection of its members by the states, including the compliance with the U.S. Constitution and congressional regulations, and forward it to the House for whatever action the House wishes to take. And it appears that Minnesota Supreme Court is doing that. And also to consider the allegations of misconduct by election officials, that is, public officials with directly election-related duties, in the 2012 CD4 election, but also with respect to the 2014 congressional elections. Plaintiff has announced, stated, and affirmed in those state proceedings that he intends to be a candidate for office, and does so again in my declaration I submit in support of this response. And also, my November 8, 2012 announcement as a candidate for the 2014 federal congressional elections can be viewed on my YouTube account. As such, the record now includes admissions by defendants in those proceedings, which is drawn from their response attached as Exhibit A to my declaration in the state election petition proceedings. It also includes factual admissions by the Democratic Farmer Labor, or DFL party, on its practices, which are at issue. The record further shows defendants taking legal positions which contradict the positions they have asserted here, undermining and abandoning their contentions that their actions were required by Minnesota law. Defendant's instant response does not deny that Secretary Ritchie is a member of the DFL party, amended complaint, paragraph 16, that the party requires quotas or proportional representation in the selection of all delegates who make the endorsement decision for the party, or that Representative Betty McCollum is endorsed through this kind of skewed and unlawful system, identical at paragraph 17. They do not deny that as a result of this, quote, the DFL party, rather than be a state-sponsored and regulated forum where partisan candidates for office can be selected to be put on the official ballot, becomes a magnet for those supporting women's issues, gay and lesbian issues, and minority issues, etc., and the entire Minnesota political and election system, including the selection of judges for both the U.S. and state courts, becomes utterly corrupt based on suspect classifications in violation of the Equal Protection Clause of the 5th and 14th Amendments. This also violates the First Amendment as set forth infra, including the right of association, of political debate and discussion, and to petition the government for redress to grievances. And that is also from the complaint, paragraph 17. The court may take judicial notice of the facts admitted and positions taken by defendant Ritchie and his party, the Democratic Farmer Labor Party, in the state proceedings. Defendants and the DFL have admitted in state court that they do indeed enforce these gender and racial quotas, but assert that they have a good purpose. Furthermore, they have admitted that the state, through Minnesota Statutes 202A.16, caucus, who may participate and vote. Subdivision 1, eligible voters, and Subdivision 2, agreement with party principles, forces all voters to stay away from the precinct caucus or alternatively not participate or vote in the caucus. As follows. Subdivision 2, agreement with party principles. Only those persons who are in agreement with the principles of the party as stated in the party's constitution. And that's these inclusion principles which set gender and racial quotas in order to be a delegate and therefore in order to participate in the endorsement of the DFL candidate for Congressional District 4, Betty McCollum, and who either voted or affiliated with the party at the last state general election or intend to vote or affiliate with the party at the next state general election may vote at the precinct caucus. So there are restrictions on voting that are set in the state law, and those restrictions on voting per the DFL Constitution restrict the proportion of white men to 35% and give women generally a majority of 50.4% or more, because it's hard to have 0.4%. And if you take all minority groups combined, allow 15% for that group. And it should be noted that no minority group has more than 5%, and therefore they may not be represented as a group singly because the principles in the DFL Constitution require that they be 10% of the population. So the only group that really benefits would be women and possibly seniors. And Subdivision 3, decision by caucus vote. In case the right of a person to participate at the caucus is challenged, the question of the right to participate shall be decided by a vote of the whole caucus. A person so challenged may not vote on the question of the person's right to participate. Again, this is the state law that I challenge as unconstitutional as applied in this case. Further, defendants admit that the DFL Constitution is filed with Secretary Ritchie per 202A.12 State Convention Authority of Subdivision 4, Constitution filing. Quote, the chair of the State Central Committee of each party shall file with the Secretary of State a copy of the party's Constitution and all amendments to the Constitution as they are enacted. Unquote. Yet they deny that he, Secretary Ritchie, has any responsibility to evaluate the principles in those laws, those bylaws, to see if they are constitutional. This is a moment when he claims not to be Secretary Ritchie, but File Clerk Ritchie. In their state response, defendants evidently frivolously contend that Ritchie is not Ritchie Chief Elections Officer whenever he engages in political and election-related activity himself by participating in, but at the same time certifying results of caucus votes, convention endorsements, and election certifications. But obviously, like Representative McCollum, Ritchie knows very well that these principles are read at every caucus, regional, and state convention, and are grounds for challenge to a delegation that does not have the proportional representation. That is to say, 50.4% women and 15% minorities. Yet he has the responsibility to enforce them under the voting and participation statute. And discovery will show that he has attended, is aware, and participates in their enforcement. Regarding the email addresses he refused to release during the 2012 election and continues to refuse to release, Ritchie, in his response to the 204B.44 petition at the Minnesota Supreme Court, begins with the same argument that he is absolutely prohibited by the, quote, public information list section of Minnesota Statutes 201 from releasing any but the enumerated data. However, beginning on page 33, Exhibit A, he admits, quote, the Secretary of State may provide copies of the public information list and other information from the statewide registration system for uses related to elections. Minnesota Statutes 209.091 Subdivision 4. And Secretary Ritchie stipulates to the fact that the use to which I would have put these email addresses, that is, contacting the registered voters in Congressional District 4, and we don't know how many of these email addresses have been provided, but there are 382,000 registered voters, and I was provided with their phone numbers. And he admits that IPAD, the administration department, has ruled that information not on the public list retains its presumptive status, that is, presumed to be public, under Minnesota Statutes 13.03 Subdivision 1. And footnote 5 is that this is the only reference defendants have made to the very material presumption of public information status under Minnesota Statutes 13.03. And so defendants from the very beginning have misled this court in the heat of the elections on the applicable state laws and facts of this case. The email addresses are public information under state law, and were they not, the U.S. Constitution would require it. On page 34, Defendant Ritchie claims that Section 201 did not bar him from releasing the email addresses, but on the contrary, confers discretion on him to do so or not. Thus, defendants admit that Ritchie simply decided in his discretion not to release the addresses. Defendants take the position that the law, quote, explicitly grants the Secretary of State the discretion to decide what information, both from the public information list and elsewhere in the statewide voter registration system, will be provided to the public, which is necessarily to say that he may decide not to provide that information.